tape. Court does call the case of People versus Richard Jefferson.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Jefferson. Mr. Jefferson, could you please state your name for the court?
Richard Jefferson.
Right here is where the groundwork is being laid for one of the most strategic moves in criminal defense, the waiver of the preliminary examination. For those unfamiliar, this hearing is the prosecution's chance to show probable cause, essentially proving the case isn't baseless. By waiving this step, Jefferson and his attorney are signaling something significant. They're leaning toward a plea deal. But here's the twist: the defense immediately draws a hard line in the sand, absolutely no MDOC prison sentence. That means they're negotiating aggressively to keep Jefferson out of state prison, even before the formal plea is set. It's a risky move. Waiving this hearing removes an early safeguard for the defendant, but in exchange, it shows the prosecution they're serious about resolving the case. Question for you: would you waive a hearing that's designed to protect your rights if it meant possibly avoiding prison time?
Your Honor, we're going to be waiving the preliminary examination. There's been, we'll say, plea discussions going on right now, and they're not 100% there, but the baseline that we've worked out is that there'd be like a no MDOC sentence agreement, and with that, we're prepared to waive.
That is correct.
So the agreement is no MDOC sentence.
Yes.
That's as
We're
far as.
discussing other parameters of the plea, but at this time, we would agree to no MDOC.
All right. Mr. Jefferson, you're waiving your right to have a preliminary examination?
Yes, I am, Your Honor.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed?
Yes.
You understand that you'll not, by waiving, that you will not have that hearing, that you'll proceed to circuit court for further resolution?
Yes.
All right. People also, for the record, made their way.
You want me to do an additional matter of right now, it's the prosecuting attorney for the people.
Yeah, but it was going to, you know. I didn't mean it. I didn't mean it that way.
For an additional matter, we want to make sure it's clear for the record that if for some reason it doesn't resolve in circuit, we wouldn't come back down here, we would then proceed to trial.
Right.
No argument with that. This is not like a conditional.
Yeah, I did not. Well, the only thing that might be a failure of it would be the MDOC sentence, at least at this point, right?
Correct, I mean, the only way we use that happens is if there's a violation.
All right. You understand that, sir?
Yes.
All right. Did you guys waive?
Did we just
Yeah.
waive?
We do.
Yeah. All right. Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Bernstein.
Your Honor, we ask the court to please waive any further reading. Ask the court to enter a not guilty plea.
Defendant waiving reading of the information. Pleading not guilty, court will enter that plea. Pretrial in this matter will be set. December 3rd, 2025, 1:30 before Judge Conlon.
And Your Honor, he did find himself in this currently incarcerated position as the result of bond violations that was adjourned to today as well. For what it's worth, he is prepared to admit to that at this point, those bond violations, and hopefully bend the court's ear regarding like a release to inpatient treatment type scenario.
So as to the violations of alcohol consumption and tampering, he would admit to those violations?
We're admitting to him, yes, Your Honor.
This is where everything shifts. Once Jefferson admits to both alcohol use and tampering, the entire courtroom dynamic changes. Judges treat bond violations as red flags, especially tampering, because it suggests an attempt to avoid detection. The defense does something smart here. Instead of fighting the violations, they reframe them as proof that Jefferson needs structured inpatient treatment. It's a bold move, admitting the violations but arguing they highlight a deeper struggle rather than a disregard for the court. Meanwhile, the prosecutor pushes back just as forcefully, insisting Jefferson must first enter the ARMS in-jail program. This is one of those classic courtroom clashes, rehabilitation versus structured correction. Both sides want accountability, but they disagree on where that accountability should begin. If you were the judge, would you send him straight to a treatment center, or make him earn it by proving he can follow rules inside the jail program first?
All right. The court will accept that admission. And what are you now asking?
We're hoping that the court would consider a release to inpatient treatment, residential treatment. Obviously when there's a violation like this, it spells out, what's going on, and that help is needed, Your Honor. And so we're not asking for just straight release into the world, but if he's able to be released to an inpatient treatment facility.
Any response to?
You would object to inpatient at this time, but we would ask for to do an order for him to do John Barnes in jail and start that treatment for alcohol. And at that time, and see how he does. And then hopefully we get a resolution for pre-trial. Maybe inpatient treatment after that.
All right, what I will do is, how long has he been in?
The PCC date, 2 weeks ago, yeah.
So he's been in 14 days. All right. So what I will do is I'll sentence the defendant this way. Sentence the defendant to 90 days.
Now that the dust has settled, let's zoom out and look at the big picture. Richard Jefferson's hearing was more than a routine appearance, it was a strategic crossroads where legal maneuvering, accountability, and treatment needs converged. By waiving the preliminary exam, Jefferson effectively pushed his case one step closer to a plea negotiation focused on avoiding MDOC time. His bond violations complicated things, but his immediate admission likely helped soften the court's response. The judge ultimately crafted a balanced ruling, 90 days with credit for time served and a path to early release if Jefferson completes the ARMS program. This decision reinforces a crucial principle: accountability doesn't have to clash with rehabilitation, sometimes the justice system can blend both. As the case moves toward Judge Conlon, the question becomes whether Jefferson can follow through and prove he's ready for change. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
For 14 that he served will indicate defendant is completed on firm's in jail program. And then if completed, consider early release from this sentence. And I say that, but all of that certainly at this point is going to be up to Judge Conlon in terms of how he wishes. All right. Okay.
Your Honor.
This point is about will continue. Thank you. Wow. Okay.
Number 4, you will be there.
Depends on which word you want. Yeah, I know.